Welcome, everyone, to another event in the Peaceful Presence Divorce Coaching Lunch and Learn series designed to help us navigate, rebuild, and heal on the journey of divorce and family court. If you have any questions during today's event, just put them in the chat and we'll make sure to get your questions addressed during the Q&A portion at the end of the event. Just a quick note that our guest today can't give legal advice about your specific case, but she can absolutely ask questions about strategy as it relates to self-representation in family court. And just a quick reminder before we get started that today's event is being recorded for those who couldn't make it live. So with that, let's get started. And I am thrilled to announce today's guest speaker. Tracey Bee is a former family law attorney with over 20 years of experience in high conflict divorce and custody. Currently, she's the founder of the Divorce Solutionist, where she provides guidance to those who are self-representing in family court. Tracey focuses on the importance of strategy as the means to successfully navigating the complex family court system. Tracey has helped thousands avoid the most common mistakes and helped people save over $750,000 in legal fees. Welcome, Tracey. I am so excited to have you here today to chat about practical pro se strategy in family court.
Thank you. Thank you so much for having me. This is going to be awesome.
Yes. Why don't you start by telling us a little bit about yourself, how you got to this place on your journey, and whatever you want to share with us about that.
Sure. So as you mentioned, I am a former family law attorney. I first profession was in mental health, so it kind of made sense to be in family law for so long. But before I got in family law, I did a few other areas of law. And I remember in the last area before family law was criminal law. And I remember my colleagues saying, hey, you're going to family law, you're not going to last there. And I said, it can't be any worse than criminal law. And they all assured me it was. And actually it is. But I loved it. I still love it because I still feel like I'm doing so much. So I left the practice to go have my son. I had him later in life. But in that time, I lost a lot of loved ones. And so I took some time to really evaluate what I need to do to make a difference while I'm still here. Yeah. And I remember being in private practice and a lot of people coming to me telling me that they could not afford the $35,000, $40,000, $50,000 in legal fees. And so they always asked for an option to do it themselves. And as an attorney, you can't really, it's kind of counterintuitive to sort of give them advice. But when I went through my own personal journey and revelations, I decided, yes, this is what's going to make a difference. And so for the past 6 years, that's what I've been focusing on, working with people who are self-representing and helping them navigate, not just navigate, understand the truth, the reality of family court and its process. Because a lot of people tend to think it's about fairness and justice and all that. And until they talk to me and they realize, no way, that's not what it is. And so here I am. So yeah, I've worked with so many people all over the country, helping them self-represent or even deciding if they should self-represent for the past 6 years. And it's been amazing. It's been an amazing journey.
Well, thank you so much for the work you're doing. It is incredible and so needed. And, I have my questions that I want to ask you, but something you just said, I want to start there with whether or not they should even self-represent. So, I think that's a lot of people's first question, like, do I need an attorney? Do I not need an attorney? Can you tell me a little bit about helping people realize whether they need one or not?
Yes, absolutely. So what I've realized, because I'm an altruist, I'm this, this person that thinks I can save everybody, I can rescue everybody. So when I started doing this work, I worked with anybody who wanted to self-represent. Well, in that time, I also realized that I was doing them a disservice. Not everybody should self-represent. Number one, if you're coming from an abusive relationship or abusive dynamic, you probably should have some representation, especially if it's, it's more severe or prolonged or chronic. You really want to get some assistance from a legal, from an attorney who actually knows the ins and outs of TV situations. If you have any sort of mental health issues, that compromises your ability to stay focused and to think straight and to be organized, you probably should have the assistance of an attorney. If you actually are, believe it or not, if English is not your first language, you probably definitely should not be self-representing. Now, that doesn't mean you can't self-represent at some point in your case, but throughout the duration of the case, definitely not. And then when it comes to complex, really, really complex issues like a parental alienation, I always suggest people get attorneys involved. When there's a lot of assets that needs to be uh, located first, let alone appraised and assessed, you probably should have not just the assistance of financial experts, but from an attorney as well to help you sort of organize that and position that, whatever you find, so that you're not overwhelmed by the time you get before the judge. But yeah, those are the precise situations and scenarios where you should really consider hiring an attorney, at least for the most important portions of your case, which is any sort of court appearances. You are going to need someone to go in and advocate for you in those specific scenarios.
That's really helpful. Yeah, I mean, like the standout things are, so much. Most of the clients that I work with as a divorce coach are victims of non-physical intimate partner violence, which is basically everything but, physical abuse. And it's very insidious abuse. And, we know that the more insidious the abuse, the more traumatizing it is to the brain because it's so hard to explain. And for so many of those people, they're in this constant state of fight or flight, which means the executive functioning required to manage your own case. It's just so challenging to get your brain back online in that space. So I think that's really helpful. And then something else I heard you say is, especially for court appearances, remind me where you're located, Tracey?
I'm in New Jersey.
Okay. So in Colorado, we just had a law pass where licensed legal paraprofessionals can represent you in court. So that means you can pay not like for full legal representation, but somebody to help you file the paperwork. And then, they're not doing the day-to-day emails back and forth with opposing counsel, which can get really pricey, but they're helping understand like the process, what the laws are, file the paperwork. And then now they can even come to court with you and help you, face your abuser or face really combating opposing counsel. And so that's fabulous. Is that something you have in New Jersey as well?
No, we don't. And I do believe a few more states are going to actually adopt something very similar to that because of the direction we're going right now. It just makes much more sense to do that. And yeah, I think that's
okay.
all.
Fabulous. Well, that's a great place to start. Do I need an attorney and do I not? So for the clients that are pro se that you work with, I guess, what are the biggest mistakes that you say pro se parties make that you are coaching your clients through?
They don't start with the basic information. It's always best to know exactly what what kind of divorce your state allows, the grounds, what custody is, whether your state does automatic 50-50 or not. You need to know the basics. And when I say that to people, they say, well, what does that mean? That's why I'm asking you. Well, you do your own research. And you know what that entails? Literally Googling family court, add your state, add your county, and that's it. And what will probably come up is the top three: your court, the nonprofit or legal aid in your area, or something very similar. And then that's going to give you a wealth of information, because what I see people do often, especially as pro se, they'll go and ask other lay people, oh, hey, how do I do this? Or what do I do? Even people who think they know the system because they've done it, they've been through it. You still need to do your own legwork. You need to get your basic information on your own so that you know the right questions to ask and you know how to move forward. And what it also is going to do, it's going to help you gain at least the minimum level of confidence you need to push forward no matter what comes your way. Because going in blindly and allowing other people to provide information for you is just giving them more of the control that you've probably already given away to begin with. So do yourself a favor and just start with, like I said, going online, and even ChatGPT, just going online, ChatGPT, and just looking up exactly what the basic information regarding divorce, custody, property division, all those things are for your specific jurisdiction.
Yeah, that's a really helpful place to start. And, I know in Colorado, the family court website has links to, information to educate yourself. There's a number that you can call. You can even go to the clerk and ask them, how do I file this? What are the deadlines? Things like that. And is that something like, That's a really big mistake, not knowing, what your state laws are and county rules and, how to do it. What are some other mistakes you see people make that really hurt their case that are simple that can be avoided?
A lot of people think that they have to jump right out there and go and talk to 5 different attorneys who are giving free legal advice. No, let me tell you something about asking for free legal advice from these attorneys who are giving free consultations. They're doing nothing more than what Google is doing. They're providing, they take that and they feel confident that they have information to move forward. They know now. You don't know. You don't know any more than what you would have known had you Googled it. If you're gonna get a consultation, you should get a consultation, at least one, ideally 3 paid consultations with attorneys who are qualified in your specific jurisdiction, not in another county way across your state. Because they're gonna know your judge, they're gonna know the structure of your court, they're gonna know how things are done in your court, they're gonna know those things, and that's what you need, especially as pro se. You need those gaps to be filled. If you're going to do this pro se, there are things that local attorneys are going to know that you're never going to find out on your own as pro se. And not just a matter of, researching and reading or doing going to the websites for the court and any other legal organization in your area. You still need to have those gaps filled. And having at least 1 or 2, ideally 3, paid consultations is the way to go. Not free. Unfortunately, free is nothing more than this is a public, is a in-person ad. That's all it is. So yes, get those paid consultations and use that information. Take notes, ask specific questions, helpful questions, and then decide from there what you're going to do. But that's definitely something that they overlook a lot. People say, I don't have money to hire an attorney. Well, you have money to get a consultation, I'm sure. If you just forego a couple of weeks of coffee, you'll come up with the $250 to $375 to speak to an attorney. And that's priceless. It's going to save you so much more in the long run.
That's brilliant. I mean, yes, if you have those basic questions, but you don't want to pay a full retainer attorney, ask during the consult, which is fabulous. You said something about like knowing the judge, asking the attorney about the particular judge. My mentor, who I was trained by, Tina Swithin of One Mom's Battle, Divorcing a Narcissist, talks about how when she was pro se, she would go sit in the courtroom for her family court judge and watch them to study them. Like, who is my judge? How does my judge behave? What do they like? What do they not like?
I was going to
Yeah.
get to that. That's incredibly important. And unfortunately, since the pandemic, a lot of courtrooms are closing the courtrooms off to people who are just coming in to observe. And honestly, we all have the constitutional right to go into the courts or public forums. We are supposed to be able to have access. So, but there's no one fighting them to say, hey, you know what, you're violating American citizens' rights by closing the courtroom. They are, but it's not moving fast enough. So what you can do as an alternative, though, you can go to the court, and if you see attorneys or litigants coming out of the courtroom, you can ask them what's their take, what's their view on. You can ask the clerk, you can ask the staff, anybody in the vicinity of your specific judge who has access to your specific judge. You can bring them a cup of coffee as a courtesy, as a show of your gratitude, and ask them, hey, what do you think about that judge? Do you think they were fair? Or do you think they listened? But you absolutely need to know who your judge is. If you're going to be in front of a judge that's going to make decisions about your children and your future, you need to know what their disposition is. You need to know what their preferences. You need to know what their habits are. You need to know how they operate in their courtroom, because they're not all the same.
Yes, it's so true. Which is kind of the frightening part, right? Is that there's so much judicial discretion in family court. And so it's really key to know your judge. That's great. So, for someone who's just starting to represent themselves, where should they focus their time and energy first? Like, what really matters most in those early stages?
Actually, this is going to sound weird, but knowing your case, so many people, even when they come to me in general, they have no idea what their case is. All they know is they want custody, they want alimony, they want child support, and they want the home. What does that mean? What kind of custody do you want? Why do you want it? Do you want alimony? What kind of alimony do you think you're entitled to? What do you think and it's amazing the amount of people who don't, I mean, and I get it, when you're, especially depending on where you are in the grief cycle, like you said, those executive functioning skills are not going to be on par, because you might have a history of abuse, but you might also just be going through so much sadness or anger or whatever you are in the grief cycle that you're not really paying attention. But you need to get a handle of your case. You need to, I have this method called the advocate method. And I use this with my clients. And the A is to assess things. You need to sit down and assess exactly what's going on in your world, in your case, in your life. You need to know what's personally, financially, practically, logically, logistically. You need to take and evaluate every single thing going on in your world, because you know what? That's going to actually have more of an impact on your case than any judge. If you go into your case, if you go into mediation, if you go into the courtroom with, not a clear idea or a clear path of what you want or what you're trying to accomplish, guess what? You're going to think everything matters. And you don't have this limitless amount of energy where you can just, willingly exert energy all over the place. You need to narrow, you need to focus, you need to streamline things so that you are coherent and you have a cohesive plan, so that when whatever comes your way, you're not completely thrown off course and you're losing because you're distracted or you're overwhelmed. So getting an idea of what the issues are, what your case is about, what the opposing party's case is about, doing that, believe me, that makes such a huge difference. With my advocate method, A is exactly that. Assess exactly what's going on. Even the parts of your case or your situation that you don't want to have absolutely face. You have to get real. You have to get true on exactly what's going on. Do that. Start there first. Because if you don't, and you go to a lawyer, the lawyer sees you overwhelmed, you're scattered, guess what you are to them? A big dollar sign. They're going to take advantage of that. If you go to someone else and you're incoherent or you're unorganized or you're scattered, guess what they're going to do? They're going to charge you more because it takes work for them to do it. Why don't you do it? It's not hard. Now with ChatGPT, everybody uses ChatGPT to organize their documents, their recordings, their files. They do that. Don't pay anybody to do it. Do it yourself. Because I see these people popping up now charging people to do that, and it's a shame because you can do it yourself. It doesn't take that long. Take some time out, a few hours a week, focus on your keys, give it, and get organized and get things, ironed out to know exactly what it is you want and what you're attempting to accomplish. That's
great advice. Yeah. And what are like the main buckets that we should be thinking of? Like parenting time, legal custody, which is decision-making abilities, child support. What are the buckets we should be thinking about?
Those, parenting time, the parenting schedule is just as important. The parenting schedule, of course, financial support. So if you're asking for alimony, you're going to need to know, you're going to have an idea of what you need and what the other party is capable of giving, how long, because it's not going to be forever. There's only a handful of states that do, indefinite alimony anymore. You need to know a lot of people are asking for the exclusive right to the marital home. You want to know that. But the main thing a lot of people overlook is, what do you need right now? The divorce is pending. The divorce just started. What do you need right now? You need temporary. You need some things temporarily. You may need temporary custody. You may need temporary support. You may need temporarily to stay in the home. You may need temporary orders restricting the other party from actually going in and liquidating all your assets. So that's incredibly important. What do you need right now? Let's focus on right now, because 2-3 months down the line, you're going to realize all the assets are gone. They're dissipated. So now you're fighting for alimony or property division. There's nothing left because you didn't get those temporary orders in place. So those are and attorney's fees. Of course, attorney's fees, because yes, judges do direct spouses to pay attorney's fees in the case where you need an attorney, and when you need an attorney. You don't always need an attorney, but in the event you do, then definitely ask for that as well. So those are the main things. The more complex things are when you need to locate assets. Have they been hiding assets? Well, that's a whole nother rabbit hole you're going to go down, because not only are you going to have to locate those assets, you're going to have an idea of what they had or what they are hiding to begin with. And some people don't have a clue. I just worked with a client last week and she said, I don't know what he's hiding. I don't have a clue. I don't even know where to start to look. And you know what I said to her? Well, you know what you should do? Go back and look at the hobbies and the habits that he's had and see if any of those things might have lended itself to, siphoning off some money, stashing money away. Look at the people he's associated with. Look at, you know what I'm saying? Go through the mail and his email, anything you could get hold of, because you have to, if you can't locate the asset, the judge is not going to help you. The judge is not going to do the work for you. Your lawyer's not going to do the work for you. That's not their job. So that's another thing to keep in mind is, are they hiding assets? Are they siphoning assets? Are they lying about income? Are they, doing anything to dissipate anything that's considered marital property that you should get your fair share of? That's incredibly important, very important.
That's really, really smart. I mean, I love the idea of thinking about the hobbies and where it could potential, sources of funneling money go. Do you often recommend people who are pro se work with like a forensic accountant for things like that? Yeah.
I still like to work with them when they work with them, because they're just getting information. They still have to decide how to position it. And that's where I come in at. We still having a ton of information. This is another thing that I think that a lot of people make this mistake. They document everything. They have tons of documents. They have tons of recordings and videos and pictures. Guess what? Judge will never see 98% of that. Never. You know why? Because they don't have time, nor do they care. So now you have to decide. Having evidence and building proof are not the same thing. You can have all the evidence you want, but it's not necessarily proof of anything until you know exactly what the issues are and you know exactly what your judge is going to care about. And so many people think that. So that's the same thing with working with a financial expert. They will help you. Private investigators, they will gather information. What are you going to do with it though? The judge may never see this. You spent $10,000, $15,000 and the judge may never see it or care. So now, and that's where I come in at. Now we're going to position this to ensure that your judge uses this information, listens to it, believes it, and uses it to actually make a decision or ruling in your favor.
Yeah. That's one of the biggest challenges that I have as a divorce coach as well, Tracey, is, people have this, they document everything out of fear, right? That somebody's got to care about all this. And what I always tell them, sadly, is, these family court professionals, I recognize that what you're telling me is unhealthy behavior for your children. But sadly, unless it's through the lens that the family court views all cases, which is essentially the best interest of the child factors, they're not going to care. So if it doesn't fall in that category, don't even bother spending time documenting it, because it's not going to matter. And even then, how do you distill decades maybe worth of abuse and child neglect or, domestic violence down into something that's actionable and sadly bite-sized for these very busy family court judges? It's a big task. And my documentation system that I offer to people as well directly addresses that, because it's a whole aspect of your case where it's like you feel like you're drinking from a fire hose. What do I need to pay attention to? It's information overload. And so what you're saying is a really important thing to do is narrow your focus on most impactful aspects of your personal case.
Absolutely. Correct.
So smart. So smart. So who are the best experts to work with? We just talked about like a forensic accountant. Who are sort of the other like adjacent professionals that you have seen be really, really impactful? Obviously besides divorce coaches, pro se strategists, who are the other professionals you like?
Co-parenting coaches. Some of them are really, really good at what they do, and they're really helpful because judges do not like to micromanage co-parenting situations. And so many people come to me and they're like, well, the judge needs to know that he's or she's uncooperative, or she's always late, or judge doesn't care. So co-parenting coaches are really good at helping them use language and incorporate skills that's going to allow them to make their co-parenting relationship go much smoother and to keep them out of court. But also, I believe, I think it's certified mortgage lending professionals, which I just discovered, those are incredibly important, especially when there's a marital home and one party's going to buy out the other or something similar to that. Those are really, really helpful. Also, believe it or not, I think sometimes it's in some places, this is definitely, something that people use more often than not, parent coordinators.
Mm.
And the reason parent coordinators are different than parent co-parenting coaches is parent coordinators are usually an extension of the court. They usually have more direct access to key players in court. And you always want that. Well, you don't always want that, but you should want that because sometimes they can be a little biased. But if you have a parent coordinator who will help you facilitate your co-parenting agreement or your parenting plan, who has insight about how your specific judge and the county that you're in handles those issues, it's better. It's going to be much more successful with you with the co-parenting in the future. So those are important as well. I'm not a fan of people hiring PIs. I'm not a fan of that at all. I don't know.
You're kidding. Say more about that, because I feel like that's a hot topic where people are like, hire a private investigator. They'll get you everything you need.
It's starting to become, I'm starting to see people mention it more and more. I don't think people should be using PIs as pro se. I just don't, because a lot of people will think, unless they know what they're doing. You know what a lot of them do? They'll go to court and say, yes, judge, I hired a PI. Most judges don't want to hear you say that. They don't hear you. So you've expended $5,000 on a PI where you could have used that, especially as pro se. And you're in my courtroom without an attorney, but you thought it was better to go and hire a PI. A lot of judges don't want to see pro se in their courtroom as it is. So now you're telling them that you and it's your choice, but you still have to, you're at the mercy of the court. You want the judge to be in your favor. You want them to be on your side, an ally. You don't want to do anything that's going to make them dislike you or disfavor you more. So going to them and saying, yes, judge, look at this report PI, submitted to me. I spent $5,000 on it and they found all this information. Now, if you go in there and you say, hey, I found out that, he has or she has hidden assets or has property somewhere, and I just happen to find this information, you don't divulge that, then that's different. But a lot of pro se litigants will go into court and they're really transparent about how they got this information. And again, that's not, a lot of judges, I've talked to judges my whole career, and I know what they're not in favor of. And one thing a lot of them just didn't like was, pro se especially, but anyone coming to court saying, hey, I hired a PI and this is what they found. Now, if the judge said, hey, you need more information and I need to make sure it's done legally and to prove this issue that you keep bringing up, then that's different, because they're not going to say, hey, you'll never hear a judge say, go hire a PI. You'll never hear them say that. They may allude to that, but you'll never hear them say that. So I'm not a fan of it either, because if you're, like I said, if you're pro se and you're thinking you're going to go into court and, the judge's going to be really, really enamored by you because that's the tactic or that's the route you took. No, it's not gonna happen. So, but if you get one and then you work with me and we go through it and I position the information that you got to show that the court that you did not expend all this money on the PI because it's not worth it. And again, a lot of times people think what PIs get is useful information. It's not. What it is, it's vindication. It's closure for them. It's not really to help them in their case. And so I'm just not a fan of people just willy-nilly just, going out to do that on their own without actually having a specific plan on how they're going to use the information in PI. Okay.
Well, and that's sort of the purpose of a PI, right? To give you the starting point of where to look to bring things up to the surface that you didn't know were happening. And then maybe you can use that as like opportunities for discovery, right? Serving interrogatories and requests for production. That it seems to be the only good reason to have a PI.
You don't have to use a PI for that. You can use a skip tracer. You can use, PIs. To me, there's other ways. There's so many apps out there now where a lot of the information, I've worked with PIs. I've found out that a lot of the information that they got from me, I could have gotten it myself. I just paid them for the convenience. Had I known that, I would have done it myself. There's so much now out there that you can get information for. You can find out if there's property that your spouse owns that they're hiding. Real property, real property. buildings or homes. You can find that out, right? It just takes a little bit more legwork, but you can find that out. But if you're going to hire somebody to just say that, to do that for you, like you said, so that you know which subpoenas to issue, discovery for depositions, that's fine. But don't take what the PI finds for you and take, like I said, and use that information as your case. That's not the smartest thing to do.
Yeah, that's interesting. Sorry for my furry friend here. He
Oh,
likes to hang out.
too, so.
Um, Let me ask you why, and I hear different answers for this all the time, but I'm curious, why do you think judges don't like pro se parties? Like, what is it that pro se parties are doing specifically? Or maybe we can even narrow that down to, like, when you're working with a pro se party, what are the 3 things that you say, do not do that in the courtroom? The judge is not going to like that.
You have to think about, and this is another big mistake people make. They think the way they think when they go into the courtroom. No. So especially when you're pro se, now you're a parent, you're a spouse, you're a litigant, you're advocate, you're all these things. But you know which role they think supersedes all of them? If they're a parent. They think, oh, the judge is going to understand because it's my kids. The judge is the judge, period. The judge is not your child's other parent. The judge just is concerned about their docket. So if you keep that in mind, when you go to court, you'll keep that in mind. So when you're pro se, the moment you walk into a courtroom pro se, you know what the first thing the judge is thinking? Oh my God, I'm going to be here all day. I'm going to be here all day because this person doesn't know rules, doesn't know procedure, doesn't know the law, anything. So this case that should take 15 minutes, had this person had an attorney, it's probably going to take 45 minutes now. So now my docket is going to roll over into the afternoon because, I have to deal with this pro se again. Number one. Number two, we're never going to get anything resolved because this pro se litigant is probably speaking from anger, from emotion, from sadness. And so there's no logic, there's no reasoning that's going to integrate their case because they're not thinking that way. And because of that, we're never going to get this resolved. This case is going to drag on for months and months and months. And again, I'm thinking about my docket, right? So you're thinking about that, Number three, don't go to court telling the judge all the things you want and you're concerned about from your mom brain, from your spouse brain. Don't do that. You are at the mercy of the court. You ask the judge. And when I say ask, I don't mean literally ask, but you pay attention. You follow their lead. If they're minimizing child support, then you minimize child support. If they're flippant about legal custody, then you of course you assert yourself, but you don't make it a priority when it's not a priority for them. You have to follow their lead. You're at their mercy. The only exception is that when you're making an objection, when you're making a record, when what they're doing is literally against public policy or against the law, and you want to make your record. And even then, you still have to remember you're at the mercy of the court. So you'll say something like, Judge, I respectfully disagree, or I respectfully object to what you just said, and then you just move on. But to go in and to fight the judge about the law, about procedure, or to try to make the judge think your top 3 priorities should be his or her top 3 priorities is a huge, huge mistake. Huge mistake.
Yeah, thank you. That's really, really helpful. So one of the other things that you mentioned is, we'll come back to that later, but tell me, what are some rights or procedural protections that pro se parties often don't realize that they have?
They have the right to, as I mentioned, you do have the right to go into a courtroom and sit and watch a judge. Even if a judge says, hey, excuse me, what are you here for? Do you have a case? And you say no, well, you have to get out the courtroom. You have the right. You're a citizen. That's our First Amendment right to be in a courtroom and actually observe. Now, from a practical standpoint, will you do that? That gets really tricky. In that situation, you probably want to escalate it, and you still have to be diplomatic in the way you do that. You have the right to record. Everything that happens in the courtroom, you have the right to have it recorded, and you should have it recorded. Absolutely, you should have it recorded. If they don't offer it to you, you tell the judge when you come back, or you're going to stop the proceeding right now and you're going to come back with a transcriber, with a court reporter that you want, that you choose. You're going to have to pay for it, unfortunately, but you have the right. And you need that, because if there's no record of anything, any wrongdoings in your case, how can you bring that up later? How can you appeal it? How can you move for post-judgment relief? How can you do anything? There's nothing that you have to substantiate what happened in court. You have the right to have it recorded. Absolutely. You have the right to be heard. You have the right to be heard. The unfortunate thing is that differs, that varies based on who the judge is. And so if you're not heard, then you, again, judge, I respectfully object to the fact that I was not given the opportunity to be heard, because you do have that right to be heard. You have the right to be pro se. You have the right to be pro se, believe it or not. So many people have said to me, I didn't know that. The judge threatened me that if I didn't come back with an attorney, they were going to, and they always do that because they're not looking out for you. They will tell you that. Oh, it's for your best interest, ma'am or sir. You need to have an, it's for their best interest. They don't want you dragging out their docket. So yes, you have the right to be pro se. And the moment they threaten you and say, if you don't come back here with an attorney, you can say, well, you know what? Chances are I'm not going to come back with an attorney. So I would like if Your Honor would proceed and move forward with scheduling this case for a hearing, trial, whatever it is that's coming up. So those are the major, because you have the, most states now have some sort of indigent service where you don't have to pay all your legal fees or your court fees, I mean. So how you do that though is going to vary. Some states like New York, you have to do it by motion. Some states like New Jersey, you just have to write a little affidavit and they decide. And some states it's easier than others and they will waive all your fees. And some states they won't waive all the fees. They will waive some, and some meaning, all meaning your transcript fees if you decided you need transcripts as well. But yes, you definitely have the right to have those fees waived, to at least apply to have them waived based on the rules for your specific jurisdiction.
That's really helpful to know. And I want to go back to you talking about the recording aspect. So here in Colorado, everything is automatically recorded. There's a microphone on every table and everywhere. It's automatically being recorded. And then if you choose later that you want to pay for the transcript, you can do that. Does that happen everywhere so far as you know, or do you have to specifically request it in some places?
Some places I didn't know that. I just found this out recently. There's some places where there is no recording. No one's recording anything. And if you want a recording, if you want it recorded, you have to hire someone yourself. You have to pay for it yourself and bring that person and have that person show up to your appearance in court to record it. Yes, that's insane. That's insane.
Wow. I had no idea. They just automatically, every state where I've worked with clients, because I work nationwide, it's just automatic. So that's good to know that it's not in every state. And, like you were saying, that's so helpful. If you want to file an appeal, you need to have the transcript. If you want to impeach someone, by saying, proving that they lied on the stand, you have to have that transcript.
Absolutely.
And so it's really, really key.
Even if you wanted to go back later on for modification or whatever, believe it or not, but people don't think this way, get your transcript. Because if you're going to go back for a modification in any respect or even contempt, you want to know exactly what the judge said, exactly what the other party said, so that you can use that information in your motion. You're more inclined to get the judge to listen if you say, well, Your Honor said on this date, in court on this date, A, B, and C, and the transcripts are attached here. The judge is going to be more inclined to say, oh, wait a minute now. This was said on the record, like this was said in open court. So yes, this is a good position to start from, and it justifies, the moving party's request or demands for whatever they're seeking at that moment.
Great. So that's a good question for the clerk then. I guess if you're pro se, whatever county you're in, call the clerk and ask, is everything automatically recorded, or do I need to bring that myself to the hearing?
Absolutely. Let me just say this. Even getting the transcript in some places is getting ridiculous now. There's some places where I was working with someone a few months ago, and she went to get her transcript from her trial, and they wanted $2,500 just for the transcript alone. And that's really unfortunate. The workaround is make sure they're recording it in a way where they have the audio. They should have an audio recording. That way, if you get the audio, you can transcribe it yourself. and you can use that, in lieu of, because that's what you're paying for. You're paying for transcribing the audio into the actual text, and then they're charging you by the hour because they need to get paid by the hour. But cut that middleman out and do it yourself.
That's great advice. That's really great advice. And then in some states, and I can't remember specifically where, but there are states who are waiving the fees for court transcripts. And that's like pending in a few states. And I know that there's a few advocates in Colorado that are trying to get that done as well. So let's hope. I know. I mean, it's a game changer. I want to talk about if you're willing to give us a little bit of your secret sauce there, to come back to your advocate method. You mentioned for, your advocate acronym, A is assess. If you'd be willing to share that acronym with us, that would be amazing.
I always look it up because
that's okay. Hey, resources are great.
Yes.
But yeah, I think that that's the framework is so helpful because, again, when people are traumatized, emotions are running high, they're, having to ward off abusive co-parenting behavior at the same time as they're strategizing their family court case. Having an acronym or a toolkit or a framework that they can come back to is key.
Yes. And at one point, I was actually giving away a worksheet where they can use it on their own, because I probably still have it on my website somewhere, but I would not mind sharing that. But what it does, it helps people do exactly some of the things that I mentioned, which is getting a clear idea of what their focus is, what their focus should be. Okay, so A is for assessing. You have to assess exactly what's going on in your world, in your case, in your life. That means taking a really deep dive look at what you are looking for, what you have, everything. Personally, financially, practically, logistically, logically, everything. You have to, because what happens is 8-9 months down the line, you're really knee deep in your case and you realize you don't have any resources, or you don't have the time at work, or you don't have the support system. Well, do that now. Start to figure that out now so that you're not getting to the thick of things and you realize, oh, wait a minute, I can't move forward because this is not in place or that's not in place. Do it now. Decide. You have to decide exactly what you want. You have to decide exactly. Saying I want sole custody is not enough. Saying I want sole physical custody with 70% time to myself at 30%. You have to be specific. You have to be determined. You have to be really detailed. And ideally, why?
Yeah.
Why does sole custody matter so much for you? Why can't you have joint custody and you still have the overall goal being accomplished by having that as opposed to sole custody? Validate. You have to verify any assumptions, and you have to validate any claims the opposing party is making, right? Because they're going to make claims. Some of them are just going to pull stuff out of the sky. Are they actually real, or do they actually, are they just using it as a tactic to derail you? Especially men. Men are really good at deflecting or distracting us by throwing out everything. And it works all the time. When women come to me, they're like, yeah, he said this and he said this and he's doing this. And I'm like, do you understand that these are all distraction methods? He wants to get you off course so that he can go in for the kill. And you're falling for it. But that's human nature, though. That's what we do. Sorry, my phone closed up. Observe. Observe, observe, observe. I am big on that. And I noticed that especially survivors, they don't want to observe. They want to run far, far away. Well, we're not getting any intel now. Because how do we know what his real motivation is as opposed to what his tactics are? How are you going to know that? So now you're going to go to court. And this is how people are always blindsided. They're not paying attention. They're not aware. They're not observing. So now they come to me and they'll say, hey, he or she has done all these things. And I can instantly see why. I saw it coming. You didn't see it coming because you weren't paying attention. You weren't observing. And I get it. Again, especially with DV in the background.
Yeah.
Or in the past. Consider all the possible consequences. Everything you want, yes, ideally in the perfect world, you'll get everything you're asking for. Suppose you don't. What are those worst case scenarios? Consider those. The worst case scenario is I don't get sole custody, I get 50-50. What's the worst case scenario? Okay, the worst case scenario is my child or my kids will spend 50% of the time with him or her, and I'll get 50%. But you know what? That may also mean, hey, they may be setting themselves up for failure because they can't handle 50-50. Consider that. Consider the worst case scenarios. Keep that in mind. It's not the end of the world. You have to always have that in the back of your mind. Any resources that you have, allocate them wisely. People tend to come up to me and say, I borrowed the initial retainer from my attorney and I'm pro se because I exhausted it all. I borrowed it. I can't borrow it money from anybody else because I used it all. And we're only 8 months into the case and we're just starting. Well, you know what? You didn't allocate your resources wisely. You don't need to spend $12,000 in the first 6 months of the case. You absolutely don't need to spend $12,000 in the first 6 months of the case. You don't. And that if nothing else sticks, please understand that. You can do a lot of this stuff on your own. And when it gets time for hearings or motions, then maybe. But right now, in the beginning, no. Do a lot of the legwork yourself, and you'll actually have that $12,000 that you expended or you wasted. You'll have it when it really matters down the line. Tally everything up now. Tally what's in your favor and what's not in your favor. You need to identify what your strengths are for your case and what the weaknesses are, and do the same thing for the opposing party. Do it both, because you know what's going to do when you make a list of all your strengths and your weaknesses, and you do the same for the other party. Especially if you put it on paper, it doesn't look as bad anymore. You're like, wait a minute now. All the threats that he or she was, throwing my way. Now, when I look at things, hey, I have more leverage than I thought. So now those threats are empty. I just disarmed it. Those threats mean nothing now because I looked at, my weaknesses are not as bad as he or she tried to make them to be. Tally those things up and then execute. Execute your plan. You've created this plan now. Execute. You have to make decisions. Make informed decisions and strategic moves. Execute those plans, but be strategic, be wise, be methodical. Do not do anything when you don't have enough information, when you're not fully aware or you're not fully organized and prepared. That's where a lot of people get ended up at. They get jacked up exactly in that specific area right there.
Yeah. That's such a good framework. I mean, I feel like, and for those of you watching, I will put in the show notes and the YouTube description that acronym specifically as well. I think it's a really good way to organize your mind around your case. And so I think that's so helpful. And, being prepared also, like, I think the biggest thing that I hear people talk about that's the most stressful, and at least it was for me when I represented myself, filing motions, right? Filing, motions practice, not that hard, right? Because you have time to prepare, to think. But when you get in that courtroom and you're standing in front of a judge in a courtroom, it can be very, very activating for a lot of survivors. And so, something that I coach my clients that are pro se is like, come with your plan. Literally, like, write down all the objections. What are all the things that I can object to, and how do I need to say it? When I'm getting something admitted into evidence, what are the specific phrases? Like, what's the specific phrase that I need to use to get a photo added into evidence? Or, what is the procedural things so that you don't have to remember that? You feel organized. When you're prepared, you're able to really relax and emotions are sort of dampened and you're like, I've got it. I have my plan. I'm prepared. If I forget what it is, I just look at my notes and I'm going to be fine. Preparation is the best way to stave off fear and emotionally driven behavior every single time, right? So what are some of your top tips for, that preparation, little things. I mean, I even just for emotional regulation, I always carry my little rock with me into court so that I can just, it's my touchstone, right? What are your tips?
think that's I actually often suggest people have, a little something, a little amulet or something that they can hold on to. It always helps to have somebody go with you to court, whether they are a friend, an advocate, whomever. Having that support is really, really helpful. Before you go into court, sort of do a exercise to sort of calm your nervous system, whatever that is. Not just having that amulet, but right before you go into the courtroom, envision yourself being in this space, in the most beautiful space where nothing matters, everything is love. And before you go into the courtroom, try to carry that image into the courtroom, because for a lot of people, just the environment is very intimidating and overwhelming and stifling. So unfortunately, a lot of preparation falls by the wayside, because a lot of people, when they walk into the courtroom, they forget about everything that they've practiced and they've rehearsed and all of that stuff. And so I tell people, ideally, it's helpful to have something in front of you that you can look to, you can refer to, but always ask the judge if it's okay. Do not ever go into a courtroom having notes or anything without asking the judge's permission for having that and referring to that. Because, the other party, if there's opposing counsel, they can ask for that in discovery, or they can make an objection to it. So it's always best to, again, you're at the judge's mercy. It's a courtesy. And so you need to have their permission. Another thing I say to people is, not only, a lot of people pay attention to the opposing party, pay attention to the opposing counsel. Pay attention to the wording they use. Pay attention to their tone. Pay attention to that. That's how you're going to prepare moving forward, because it's rarely the opposing party bringing the issues for you or creating the issues for you in the courtroom. It's opposing party, it's other key players, it's even the judge. So if you have an idea, and opposing counsel against pro se, they're jerks. Look, we are jerks when we know the opposing party is pro se. We take advantage, we bully, I admit I've done that. But if you still try to manage to be civil, I know it's hard, and to show them some deference, we're egomaniacs. Lawyers are egomaniacs. You will get some of them, to most of them, to sort of cut you some slack, to give you that grace by not hammering you the way a lot of attorneys do when it's the opposing party is pro se. So keep that in mind. Yes, they're going to say lies. They're going to don't argue with them. Do not
objection. Facts, not an evidence, right? Like,
just that's it.
All of that. Call them out. And something that's been really helpful too with abusive attorneys is when you're up on that witness stand, first of all, you can't take anything but a blank notebook up on that witness stand when you're being cross-examined. So just remember that, right? You can't take those notes. You can just take a blank notebook so you can take notes for your response to things or your rebuttal. But, you can object to badgering the witness. If an opposing counsel is being very rough with you and you're starting to get elevated, you can literally turn to the judge on that witness stand and say, objection, badgering the witness.
Yeah, but this is the thing. Those objections are going to vary by state.
Yes.
Yes. So that's why if you're on the witness stand in a hearing or a trial, the rules are completely different than if you're just showing up in court. So be mindful. And people tend to think that the rules that applied when they were just showing up for status conference or updates are the same rules that apply to hearings and trials. They're not. You should not be going to a hearing or trial without understanding the rules, because that's when not only the judge, but the opposing counsel will annihilate you. They will. They will make mincemeat out of you if you don't. And we know, attorneys know that the chances of you understanding the court rules of procedure are very, very slim. So do yourself a favor and spend some time understanding that. But if you're just in court and you're on an appearance, yes, show them some deference, show them, give them the benefit of the doubt. Don't argue with them. Don't engage them. The same thing with the judge, as I mentioned, defer to them. The one thing I want to mention, though, about being prepared, about, having notes, what to say and what to object to. What do you do when the opposing party objects to your objection or responds to your objection or says something to negate or minimize exactly what your position is? That's what people don't understand. You can be prepared. You can be prepared all day. You can have all your documents. You can have everything organized. If you're not prepared for the possibility of the opposing counsel or other key players or even a judge, you're not. You're not. That's where I come in at. That's why strategy is way more important than just being prepared. You have to be strategic. You have to, if you go through the advocate method, you'll understand why your being prepared is not enough.
Yeah.
You have to.
It's such great advice. I mean, knowing what to do. I think the hardest part is you have your best laid plans, right? But what happens when opposing counsel just takes your best laid plans and throws them out the window? How do you respond to that? Knowing what your rights are, knowing what to do in that instance is just so key. We are getting very close to time, and I know you have a very hard stop, Tracey, so I want to be mindful of your time. I am going to just go ahead and put out there, if anybody has any questions, drop them in the chat now while I am doing a little bit of a wrap up. Tracey, thank you so much. It doesn't seem like we have any questions, so we're just going to let you go so that you're on time for your commitment. Thank you so much for your time and for being here today and the amazing expert wisdom that you've shared with us. If you want to get in touch with Tracey, I will make sure that her contact information is in the show notes below. Her information is also on my website on the Lunch and Learn page. Really, truly, thank you. I appreciate you.
Having me. I appreciate it. This is awesome.
Stick around for upcoming Lunch and Learns that we have. We got some great Lunch and Learns already up on the website. If you want to register, you can register for as many as you'd like to. Next week, July 22nd, we have got CDLE, like you were saying, a certified divorce lender, talking about, do I keep the house or sell it? What are the ramifications? August 12th, we have got mini rituals for reconnection with self-trust with a spiritual connection of mine. And then on August 26th, we have Rising Beyond Overwhelm, Executive Functioning Through Trauma with the amazing Sybil Cummin, who is a family court expert and advocate and also owner of a lovely therapeutic practice here in Colorado. So more information, keep an eye out for that. And thank you all for being here. We'll see you next time.